Good morning, everyone, and welcome to the first of our KLC breakfast briefings with me, Kaz Carrington. For those of you who aren't familiar with KLC, it was established about 50 years ago now, actually, and among other services, we've been providing employment law advice, employment law training, and employment representation at employment tribunals ever since that time. In fact, we represented the respondent in one of the first tribunal cases ever. They were called industrial tribunals back in those days. There were 3 cases. We literally had to pull straws for who went first. We drew not the shortest, not the longest, but the middle straw. So we went second. So depending on whether you're glass half full or glass half empty, it was a good day. As well as providing in-company employment law training, we also have written and presented the Law on Tour for about 30 years now, which in normal times runs twice a year, in the spring and in the autumn. However, this year is anything but normal, and so we're going to be running it in the summer this year. So do look out for our advertisement in People Management that will be running in March, and if you want to contact us about the Law on Tour, please feel free to do so. It's a complete employment law update. It's a day's course. We run it at events around the country, but we're also going to run it virtually as well. So we'll be out there again, beginning of July. Okay, so our first 30-minute briefing is on disciplinary investigations while acting reasonably within the law. Because if we don't act reasonably within the law, then it doesn't matter what else we do that's right, it'll all go horribly wrong because it will be an unfair process. And that will mean that any subsequent dismissal will be unfair as well. I'm not going to take any questions during the briefing because time is limited, obviously, but I'm very, very happy for you to email me with your questions, and I'm going to put the email address up at the end of the briefing so that you've got time to jot it down. So please do that. Okay, so let's get into our first slide. So we're going to be about 30 minutes-ish, give or take. And this is what I'm going to be discussing over the next 30-ish minutes. So first off, we'll look at what's important in investigations. So professionalism, compliance, natural justice, why does it matter? Well, it matters because we have to make sure this investigation meets the standards of the range of reasonable responses, which I'll explain a little bit about in a little while. We'll look at the skills required, we'll look at the planning involved for investigation, what happens during interviews and what we have to plan for, how we have to conduct ourselves, and what we'll do if we have witnesses which or who really don't want to talk to us or they want to remain anonymous, and witness statements, what form they should take if we need to anonymise them, how we do that, how we redact, and then finally report, whether we are making a report. That's generally the case these days, that the person who's going to hear the disciplinary matter wants a report. Sometimes we just have to give over witness statements. As I say, more and more again, these days we're asked for a report. So we'll just look at what's required in that to help the decision maker make that very important decision. Okay, so first off then, this issue of professionalism, compliance and natural justice, the principles, if you like, of this. So what is the investigator trying to do? What is their raison d'etre? Well, it's to look for the truth. That is, talking to people who have first-hand knowledge of the incident or event that occurred or allegedly occurred. And nothing more. We don't want hearsay. We don't want somebody who saw somebody else do something. So that's the first principle. Second really important principle is, of course, maintaining confidentiality, maintaining the integrity of this investigation, because if we allow it to become tainted because other people know about it, too many people have had their say in it, then we lose the integrity and we then lose the fairness of the investigation, and then the whole process becomes hopeless and unfair and won't stand up if we end up having to defend ourselves at tribunal. Treating all our interviewees with respect. Well, of course we would, Cass. Why wouldn't we do that? Well, sometimes if you have an allegation that maybe personally to you is abhorrent. It might be something to do with harassment or discrimination or racism. It might be difficult to always maintain that professionalism and treat people with respect, bearing in mind that everybody, even the alleged perpetrator of this alleged incident, really kind of, we have to assume their innocence. We're going in there, we're just looking at the truth. And so we have to really, really try to make sure that we treat all interviewees in the same way. And again, that becomes something that you do with experience sometimes. And sometimes it can trip you up when you are faced with maybe an allegation that is particularly nasty. Giving equal consideration of the evidence that supports but also rebuts the allegation. What do I mean by that? Okay, let's say that you interview 10 people. Let's say 9 of those 10 give you a version of events which is more or less in line with each other. And then you interview the 10th person and their version of events is completely different. They might have a different slant on it, or indeed they might give you some information which really flies in the face of everything else you've heard. It is human nature to, I guess, subconsciously sort of push that aside, not to bury it exactly, but to give it less credence. And really what we're saying here is, well, that could be really important. So while you might, when you're looking at the balance of probability, think, well, it's likely that that didn't happen, you've got to actually show that you've given it full consideration. There are data protection issues when we're looking at investigations because we are collecting and processing personal data. So we have to make sure that we observe all the requirements of the data protection laws, that we're following the Information Commissioner's advice on whether it be monitoring or whether it be keeping data. And bearing in mind that we'll be sharing information, so we need to make sure that we've covered ourselves in respect of that. And having this consistent approach. Now, time and time again, we'll see investigations which are done sort of rather a haphazard way. And what we're looking for here is that although every investigation will be different in content, of course it will, because there'll be different allegations, there'll be different witnesses, it would be really good if we could say that every approach is the same. So every investigation plan for your organisation is the same, it's consistent. Every report is written in a consistent way. Why is that important? Why should it matter? Well, what you're looking to show, remember, is you've acted reasonably and fairly within the law, that you have acted in a professional way. And the way that you can demonstrate that is to show that everybody in your organisation does things in the same way. This is the process that you always follow. And in that way, you can show more that you know what you're doing, you gain credibility, and therefore you're more likely to be believed if the issue goes to tribunal, but actually the investigation is a fair and proper process. I mentioned the band of reasonable responses, or the range of reasonable responses it's sometimes called, and this is important because the Court of Appeal had looked at this many years ago and said, actually, investigation, you should look at the quality and the fairness of investigation in the same way as you would look at the decision made to dismiss somebody. It has to meet those standards. So remember, it's got to be reasonable. It hasn't necessarily got to be a platinum plated affair. You don't have to have pulled out all the stops on every single occasion and interviewed every possible person who could possibly have any piece of information, but it has to be reasonable. So you have to meet those standards. So we're looking here for a good quality investigation, something that has got that stamp of professionalism on it. And it is the starting point. And so if this investigation goes wrong, of course, everything else is going to go wrong in turn. And very often when we are sent information, maybe about a case that the client wants us to deal with, the investigation sometimes is so poor that really it's not a starter from the get-go. So it's really important to do that. So it will help us if we end up in tribunal. Hopefully it will prevent us from getting there in the first place. But just to remind you, if we do end up in tribunal and we have got a poor investigation, which is so flawed, that it's rendered the dismissal unfair. These are the sort of awards we're looking at. So remember, if it's an unfair dismissal, that's the maximum basic award, 16,140. Remember, we have the compensatory award as well. Also, if it's whistleblowing or health and safety, it's going to be unlimited compensation. And obviously injury to feelings for detriment for whistleblowing dismissal as well. If it's discrimination that's being claimed as well, then we have issues with vento. So we've got injury to feelings and we have a compensatory award. So that's just really to remind you of the sorts of levels that we're looking at there. Okay. The skills that we want our investigators to acquire or to have innately, it's vital, this process. Very often I get the impression that sort of the investigator's role is, somebody just tells them, go off, investigate this matter. And sometimes it's a simple matter and it doesn't require all the skills that I'm going to talk about. But sometimes it's more complex and it does require a particular approach, a particular skill set. And so I suppose, first off, say that if it matters to you, if it matters about having fairness in your process, to be fair to your employees, but also to make sure that you are protecting your organisation, then make sure your investigators are trained, that you pick people who have got either those skills innately or that you provide them with the training. Very often it's a good idea for a new investigator to maybe take the notes for a more experienced investigator, allowing them to get some experience sort of on the job rather than just be thrown in at the deep end. So what we're looking for here in this very, very important role is somebody who has got a mixture of skills. And it's quite odd really, because they're both really ends of the sort of spectrum in terms of people who are highly methodical, people who are very organized, and those people who are just, sometimes fly by the seat of their pants, and they've just got really good interpersonal skills. So what we're looking for here is a mixture of those. So a methodical approach, planning, somebody who's got good analytical skills. And when we come to look at the results of our interviews, our witness statements, our findings, we need somebody who can actually take that information in a logical way and make something readable for the decision maker. So we need somebody with all those good skills, but also we need somebody who has got those skills that make people feel at ease, that make people feel respected, that allow a degree of, if you like, on the spot thinking. So you might have a plan, but you've changed your plan because you see actually that there's something more interesting, or the interviewee has something that they might be holding back. So it really requires a mixture of these skills. As I say, some people will have these innately, some people will learn them, but they can only learn them obviously if they can experience those by either training somebody or being taught those skills. Now, we come to the role of HR here, I suppose, and you may be in a situation, you may be in HR yourselves, you might just be a business leader, but if you are in HR, you probably will be giving off the investigation to somebody else. Some HR folk do the investigation, so it really depends on what your role is. But if you hand off the investigation to one of your trained investigators, then clearly you have to know the limitations of your position as HR. Now, there's two cases up there. Rampfile is the first case, and that was the first case where we really saw HR really getting too involved in an investigation. And the idea was that it was an investigation into, I believe, it was expenses, potential fraud. And the investigator went off and looked at it and said, well, actually, I just think it was an honest mistake, that they've claimed incorrectly. And HR got more involved and said, actually, no, I think you're wrong. I think this is gross misconduct. So what happened was, effectively, HR overstepped their remit. And the EAT gave advice on this, and they said, look, really, it is HR's role to advise on consistency of approach. it's HR's role to advise on compliance, both with the law and with company procedures, and to make sure, obviously, that everything has been investigated that should be investigated. But it's not their role to look at credibility or to look at culpability. And so that's kind of something to remember. Sometimes it's very difficult if you think somebody's going completely off-piste to be hands-off, but that's where we come back to the issue of making sure that people who investigate for you are trained and know what they're doing, and then you can have the confidence in them. The Cadent case is slightly different from that, but it's a much more recent case, and it's where an individual was facing gross misconduct charges, and the investigator went off investigated, but a senior or a more senior manager got involved, wanted to change the terms of reference of the investigation, indeed gave some not all the correct information to HR, shall we say. And because HR didn't push back, maybe as they should have done, again, that rendered the situation and the dismissal unfair. So it's a case of, I guess, for HR, knowing your remit, having your trained investigators who you have trust in, but also being able to withstand any pressure from maybe very senior managers who want to get involved, because that's going to taint the investigation, it's going to render it unfair. So something to remember. Coming to the planning of the investigation, and plan is what we always say. First off, there will be the terms of reference. Now, if you are investigating a disciplinary matter, it might be that that's fairly straightforward. I mean, these principles really apply to any type of investigation, whether it be disciplinary or grievance. But sometimes you'll just have a very broad term of reference. It might be investigation into an incident that, or it might be narrower. But sometimes as you go along the investigation, the terms of reference, or if you like, the complaints might be more easily defined. It might be refined. As we've mentioned, this confidentiality piece is absolutely vital. So we have to decide who we're going to tell, what and when. And that sort of means really thinking ahead. So if you're going to a different site to carry out your investigation, who would need to know about that? Well, somebody who's in charge of managing the site, but they'll only need to know that you're there in a capacity, in an official capacity. So it's really thinking through who needs to know what and when. And also thinking about what your witnesses need to know, what you're going to tell them about the investigation, about the allegation. Now, we were advising on a matter a few years ago where there had been an anonymous complaint. It had been made through basically one of the employee sort of channels where you can leave a complaint, and it was picked up, and the complaint mentioned an individual. Now, when you get the situation where you have an anonymous complaint, well, we have to observe natural justice, don't we? So it's only really fair that if you're not going to tell me your name, complainant, that I'm going to protect the alleged perpetrator. And so what we would normally do, wouldn't we, is we'd carry out an investigation in that type of way. If it were into bullying, harassment, we might go into a department or widen it a little bit so it wasn't so obvious. And we would talk about, in general terms, have you ever witnessed, have you ever experienced any bullying, harassment, etc. But we wouldn't go in there guns blazing, saying there has been an allegation. And that's what happened in the case we're advising on. There had been an allegation of race discrimination, and 20 people were interviewed. And rather than sort of going in and finding out generally what their views were about how things worked in the department, the investigator actually just said there's been an allegation that, and named the individual, has been allegedly racially harassing this person. And so immediately that whole issue of natural justice comes into play. And was that a breach of trust and confidence? yes, it was, and that would allow the individual to resign and claim constructive unfair dismissal if they wanted to. So a flawed investigation because the, if you like, niceties, the natural justice wasn't observed, the trust and confidence have gone. So often we'll be balancing those things, and that's why, you know, we have to not only have the knowledge of what's reasonable and fair within the law, but also have, you know, to use our own judgment as well. When we're planning the investigation, and this is a bugbear, I think, for a lot of the investigations that we see, it's clear when we're looking and reviewing at what happened that there was no preparation really, and that the vital documents weren't ready, easy to hand. So policies and procedures, nobody really knew what was meant to happen or what the individual knew should happen. So it's getting all those things ready beforehand. What are we going to need when we're dealing with this investigation? What we need to refer to? And also, if there's any further monitoring required, and sometimes when we're investigating matters, it comes out of maybe something that's been monitored, whether it's IT matters or whether it's CCTV. Now, are we going to have any ongoing monitoring? And if so, are we aware of what the Information Commissioner says in the Code of Practice on such things? So it's making sure that we understand that. Now, the Information Commissioner's advice on monitoring and investigations is very helpful. So if you haven't seen that before, hop on and have a look at that, because it can be very helpful, and it guides you, gives sort of benchmarks and examples, so you will know that if you follow those examples and look at the benchmarking, then you meet those benchmarks, then you will find yourself acting within the law and not out with. The other thing we have to think about is who we're going to interview clearly and in what order. And as I mentioned before, interviews don't have to be, and investigations don't have to be this platinum plated affair, but we have to make sure that we interview the relevant people. Now, sometimes the order of the interviews is dictated by who's around, and sometimes it just really doesn't matter who you interview first, second, third, etc. But sometimes where it is known that there are allegiances maybe, and in some environments, some working environments, it might be that, you know, the group of people are friendly, another group of people are friendly, and you know that there's a bit of animosity, and you might have to think through what would be logical, but also bearing in mind that it's always good to advise people that you're going to re-interview them, or you might have to re-interview them, because it's always helpful, isn't it, to, oh, I've got the information now, actually I really could go back and talk to that person. But if you think about the order of your interviews, sometimes you can avoid a lot of that sort of toing and froing. Okay, so we've talked about this issue of interviewing people being a skill, either taught or innate, and we've talked about having a plan, but we have to be flexible. I mean, really what you don't want to do is be so structured in your plan that I've got my plan, I've got my list of questions, and I shall stick to them because that's what my plan is. Now, if you do that, and if you're not listening and if you're not flexible, you could miss a vital piece of information. Not just that, not just what people say, but the way they look, the non-verbal body language, obviously, those things that you want to pick up. So be flexible, be prepared to go back and re-question. And this is why it's good to have a note taker, actually. If you have the luxury of being able to do that, then grab it with both hands, because it allows you, if you are the investigator, if you are the interviewer, to really listen, to really look, observe the individual. So remember, it's people have got a lot of communication going on, and it's not just what they verbalize, it's also that non-verbal communication as well. That's important. And again, we're not trying to catch anybody out here. We're merely trying to think, oh, actually, I think, you know, I'll go back and talk about that again, because I think that's something that the person was upset about or annoyed about or anxious about. Manage their expectations, and by that I mean in your plan, in your interview plan, you will have, I would suggest, an opening script, and write it down, and that means that you'll say everything that you need to say at the outset. So you'll tell the individual that After the interview has been completed, you will type up the notes and you'll send them to the individual, and you will expect them to, agree, if indeed it is a true account of the interview, that the interview notes are a true statement of what happened. Now, it's important to do that because you really want to get up front in there that we are going to be asking you to kind of put your name to this. It's also good to tell them up front that these interview notes will obviously be shared with the alleged perpetrator. And again, you're telling them up front, so everything you're going to tell me, this is what's going to happen with it. You are really kind of warning them that what they say will be shared, will be noted, and that then avoids the individual say, well, I'm not signing that, and I'm not agreeing to you sharing it with that person. It gets over all those issues. They have got rights, obviously, with regard to the interview, obviously data protection issues, and they have got obligations, and that is to keep stum about the investigation. They keep quiet, they keep it in confidence, and you tell them, and I would suggest that they must keep it to themselves, they mustn't share this information, and if they do, that will be regarded as a disciplinary matter, up to and including summary dismissal, because quite frankly, if somebody blabs about an investigation, ruins the integrity of the investigation, then that might actually mean that that's a gross misconduct issue. So all these things we can tell them up front, and all these things we can forewarn them of. And so we avoid those difficult issues. And often, I've heard, people say to us, oh, this person, is refusing to sign, etc., etc. Talk a little bit about anonymity in a little while. Okay, so if you allow people to be accompanied, that's fine. It's not a statutory requirement, as you know. You'll have rules in your procedure, no doubt, but just do bear in mind that if you do allow accompaniment, it is probably not a good idea to give the accompanying person the full rights that they would have under a situation where it was a disciplinary matter or a grievance matter that was formal, and the individual might be receiving a formal warning. In other words, full participation. You really do want to avoid that because you don't want them interrupting, you don't want them asking you questions. So if you do allow accompaniment, it would be good to define what that accompaniment looks like. So you are there to take notes for the individual and to support rather than have full interaction in the meeting. So questions for interviews, we prepare them, and just a little piece on how to phrase your questions. A reminder, again, investigations come down a lot of time to good interview skills, and these skills you might have gained from carrying out recruitment interviews. But just to remind you of those open questions, the things to get people talking, the how, what, why, when, those sorts of questions. And then those questions that check understanding and also kind of encourage the individual along. So you said you were standing by the desk. Can you remember exactly where you were standing? It shows that you are following the sort of train of thought of the interviewee, and it's an encouraging sort of note from you for them to carry on talking. Funneling, you want to know more about something. You mentioned that she looked scared. Can you tell me why you thought that? It encourages people to talk. Again, these seem obvious, but you will be surprised how poorly phrased some questions are at investigation interviews. The yes, no's, the shutting people up, the closing people down if we want to, it establishes a fact as well. So were you in the office at 10 a.m. on Tuesday, the 10th of October? Yes or no? It's easy. So remembering how that works. Types of questioning to avoid, the leading ones. We think we're learning something, but in fact we don't. So you thought they were under the influence of alcohol. Is that because they were slowing their speech? You are leading the person into giving you an answer. Avoid that. Multiple questions. We hear it on the TV all the time. The interviewers will give them more than one question. They will likely answer the question they feel most comfortable with, or indeed the last question in your multiple questions. Assumptive, you assume something. You've worked in this type of role for a number of years, so you know how important it is to do such and such. They might not have a clue, but you have, if you like, assumed something that you think now is a fact. And those closed choice, probably the worst, where you're giving the interviewee just, you know, a choice of one or two. And would you say they were frightened or angry, happy or sad, anxious or relaxed? Well, I don't think they were either, but actually as the interviewee, I'll just say something. So avoid those types of questions. Okay, getting back to the interview itself, listen, actively listen. And again, I don't need to tell you that we hear very much less than is going on because we're not actively listening. And one of the good ways to practice actively listening is to just listen to something on the news and then see what you can remember afterwards. Good prep for that. During the interview, be polite, but always maintain control. Never let the interviewee take over. Always be respectful, polite, but absolutely 100% professional and in control. And you might need to obviously take breaks. The idea is you're open-minded and you're demonstrating that you're open-minded as well. And that's very important. You're clear about your role to the interviewee. You're just fact-finding here. You're not making the decision about this disciplinary allegation. You are, in fact, saying that in your opening speech to them, your opening gambit to them. I'm here to fact-find, that is my role. And clearly, as the investigator with an open mind, you have no preconceptions of guilt, etc. Tell them what's going to happen next or what might happen next. After this interview, this will happen. If they're just a witness, I might want to talk to you again. If they're an alleged perpetrator and you finish interviewing them, it could be that, after this, I will obviously write up my notes. I will give them to you to look at, and then I'll write a report. And after that, it could be that everything is dropped, or it might go forward into a disciplinary matter. So you're telling the person, you're managing their expectations. Challenge at interview if you are not clear what is being said. So if somebody has contradicted themselves, say, I'm not clear, actually. You said earlier on that you weren't in the canteen, but you're now saying that you were. Were you or weren't you? You can do it in a nice professional way, but don't be worried about challenging. What you don't want, however, is to turn it into a quasi-disciplinary hearing. And what we see sometimes is the interviewee, the alleged perpetrator, will be saying, you've already made your mind up, haven't you? There's no point in me having this meeting with you because I know what you're going to write. And that baits the investigator, the interviewer, into actually getting a bit angry. And that's how it can go wrong. So again, that trained approach, that relaxed, that professional approach will prevent that from happening. Don't accept anything on face value, and wherever possible, we want to be able to seek corroboration of what somebody said. So, she was there, and we know that happened because we got CCTV of that, or somebody else saw her there. On notes, remember, sometimes people take them verbatim. Sometimes it's taped, it's recorded, I should say. But the notes don't have to be verbatim. But if there are very important things that are being said, if there are phrases, swear words, it's good to actually put those in sort of speech marks so it's clear that that is actually what was said. But they don't need to be verbatim, they just need to be an accurate summary reflection of the interview. And you might need to take adjournments and obviously advise them what's going to happen next. Now, I did mention, and I talk about anonymity, and sometimes interviewees say, well, I'm very happy to, tell you this, but I don't want to put my name to it. Now, there might be myriad reasons why they don't want to put their name to it. It might be that they are really frightened of what will happen to them. And we know in some working environments that have sort of a robust culture, shall we say, that they might be actually worried about their physical well-being. But we have to really weigh up the pros and cons of this. It could be that I just don't want to get involved. And so we would really challenge somebody in that situation. Now, what have the courts said in general? They've said, look, seeing witness statements, showing somebody a witness statement, this is what somebody said about you. Obviously, it is best to have the individual knowing who their accuser is or what somebody has said about them, but it is not a universal matter of law. It's not, completely going to be either unlawful or unjust to show somebody a summary maybe of what was said, a redacted statement. But we need to be able to weigh up the pros and cons of this issue. Now, sometimes we can do it. Sometimes we can offer anonymity, but we have to be careful that we've looked into the whys of why somebody wants to remain anonymous. Okay, so any queries raised by the person who's being accused, who the allegations against, must be put to the anonymous person, the informant. So we need to make sure that justice is done in some way. And what has the court said about us double checking ourselves when we are going to agree to anonymity? We check these things, we go back and look at the date, times, place of observations, how they could have seen these things, how what were the circumstances, why were they present, how could they have seen this, whether they've suffered actually at the hands of the accused person, and can anybody else corroborate their evidence that they're giving. So really what we're saying here is, if somebody wants to remain anonymous and you agree to anonymity, then be doubly sure that you're double checking yourself. Be cautious, be suspicious, I suppose. And sometimes people do have jolly good reasons, as I mentioned, to want to remain anonymous. We want to make sure that we can record such things as the person who wants to remain anonymous. Well, we're not quite sure why. Have they got any skin in the game here? In other words, what's the background here? Is there any reason that we should be doubly suspicious of them? And really asking the subject of the investigation, the alleged perpetrator, if there's any reason why somebody would make a false allegation against them. So these principles have come out of the EAT case and a very famous case at Linfood, Cash and Carry. Again, it gives us the principles and it makes sure that we're acting reasonably and fairly. So under normal circumstances, we want a signed witness statement. If we can't get that, we might agree anonymity. We might be able to have an anonymized witness statement. We always get that witness statement signed and then we redact anything. But of course, the more diluted the evidence is, the less likely it is to actually be fair. And so we have to bear that in mind when we're allowing anonymity. Okay, so our witness statements really kind of talked about this already in a sense. So make sure clearly that we get the individual to sign first, then redact. Always be suspicious if witness statements are identical, because that's really impossible. We all see the world in different ways. Actually, if you're witnessing an incident, you'll see it from different angles because you can't all be standing in the same place. And so just be a little bit cautious and suspicious around that. And if we have agreed this non-disclosure, this anonymity, that we won't sort of pass on somebody's name, then do make those inquiries. Okay. When we have a lot of witness statements, we sometimes have got, a bunch of them, and well, that person said that, that person says this. What we use at KLC sometimes is an analysis sheet. So we'll sort of have evidence analysis, that little matrix. And you can do that by saying, who did I get this information from? How did they give it to me? Was it, an interview, or did they write to me? What's the quality of this, and why should I query the quality of this evidence? And therefore, how much credibility should I give this? It really kind of helps you crystallize in your thoughts. Okay, so we can see the balance of evidence is is in this way. And that's very helpful, obviously, for the decision maker. So that's something to use if you have a lot of interviews. And if that's something that you're interested in looking at, please contact me and I can talk you through that and let you have some more information about that. The report, of course, again, we expect to report these days mostly in investigations. Again, we want a standard approach, we want the terms of reference. And again, this can be anything that's standard to you, but really this is what we would be looking at. What the terms of reference of this investigation? What were the allegations? What policies, procedures, documents did we look at? And what approach did we take? Did we interview them in person? Did we do it by Teams? Did we do it on the phone? Did we have any CCTV, etc.? And a chronology of events is really useful where we have a very complicated situation. You know, this happened, then that happened. It really helps the decision maker if we have a chronology of events. And then analysing our evidence. So analysis of our findings, how we've got to our findings, summary of our findings, recommendations, not ever recommendations about disciplinary sanctions. That is not our remit as an investigator, but it might be that actually during the course of investigation we have discovered that maybe a policy procedure isn't working as it should and we can recommend changes. We might have conclusions in terms of, you conclude that that the information and the summary is that the balance of probabilities that the investigation has found that maybe the disciplinary procedure should be progressed and that the disciplinary hearing should be held. But that's it. That's as far as you can go. It's up to the decision maker to decide whether that should happen and whether indeed the sanction. We never ever get anywhere near talking about sanctions. So a report is clear, concise, and it gives our decision maker a very good steer on the information and the evidence that has been gathered, rather than having a haphazard bundle of witness statements that really aren't terribly helpful. So top tips before we end, and I know I've got overrun, I did say 30 minutes-ish. Plan. Organised approach is absolutely essential. That's number one tip. Careful consideration of the allegations, and do be careful to restrict the investigation to those allegations. But it might be that in the course of the investigations, you have uncovered other matters unrelated to the allegation, which you'll want to talk about in your report and say to somebody, we need to look into this, at some point. But they don't form part, if you like, of your investigation because they're out with those particular allegations. Pose questions in chronological order to the witnesses. It helps people remember if you take them through in a chronological timeline. So that's really quite important. Ensure questions are specific, they're not generalized, and remember, prepare to challenge and probe. Don't lead witnesses, don't tell them anything that you don't know that they already know. So really think through your questions carefully. Always try to, if dates, events, times, locations are part of the investigation, to get them. Always ask and get corroboration. And never fill silences. They are really helpful. Ask a question. If you don't get an immediate response, don't jump in. Give some time. We know that actually the longer we wait, the more likely it is that somebody is going to tell us something. They're thinking, they're actually going through a thought process. So let's not jump in. And if you've got a note taker with you, remind them not to jump in and not to think that you've suddenly lost the plot. Actually say, if there's a silence, don't jump in. It's just because I want the person to have time to recall what happened. Don't let our interviewee ever take control, but don't rise the debate either. So this is something for your managers, your investigators. Don't let them be sort of riled up by the interviewee saying, you're unfair, you've made your mind up. So train them in this might happen and this is how you should respond. Remember, if anonymity is requested, we double check our evidence and we redact witness statements only once they've been signed. And we never let an investigation stall just because somebody's gone off sick. There are always ways to proceed. Obviously, we will kind of give some period of grace if the person really sort of is poorly, clearly, but we might continue either with written questions. We will move the investigation along. If somebody just says, well, I'm signed off, I'm too stressful, I can't talk to you. Sometimes we know in some sectors this has gone on for months and months and months. And of course, the longer between the alleged incident and the actual disciplinary hearing, the more likely it is it's going to be unfair. So we must move things along in a fair way, in a measured way, but making sure that we don't let the investigation stall. And don't let it be hijacked by somebody more senior. So make sure your investigators are confident and they have enough kind of gravitas to push back and say, no, I'm owning this investigation. Sorry, if you don't like it, go and speak to somebody else further up the chain. And we never, ever, ever recommend disciplinary sanctions as an investigator. Remember, that's the decision maker's decision. We will just show our evidence and say that the disciplinary procedure maybe should proceed, but that's all we say. We can make recommendations on improvements, of course, to procedure and policies if we find things are wrong. And then just one more tip. If there is any evidence, such as, oh, somebody says something on Facebook, or, oh, there's a bit of CCTV, make sure if it's on a media platform, we get a copy of it before it's taken down. And if there is any CCTV footage, make sure we don't actually record over that. It has actually happened. So make sure that doesn't happen. Secure your evidence so you have got that, and that's very solid and helpful. Okay. That's all I'm going to say. I have overrun my time, very sorry. If you have any questions for me on investigations, then do email at klc@klcemploymentlaw.com, and we'll get back to you with answers to your questions. I hope that you have enjoyed this first briefing. I know we've overrun. That's a bit of a sort of characteristic, I'm afraid. I will try to do better next time. But thank you so much for joining this first briefing. And I hope that you picked up some good sort of pointers and tips along the way. And if you have, please join me for our next briefing in March, when we'll be looking at disciplinary hearings and how to avoid making those oh so very common mistakes that will render a dismissal unfair. If you can spare another 2 minutes, to complete our poll. It's very short, but we'd really appreciate it if you did. That will help us greatly. And don't forget to look out for the ad for Law on Tour in People Management. And if you want to know anything about us or what we do or Law on Tour, then just come and have a look at our website. So until next time, thank you very much for joining me this morning. Enjoy your breakfast, and take care, and goodbye for now.